Something just happened in the American legal system that should be on the front page of every newspaper in this country, leading every broadcast and dominating every political conversation happening right now. It's not. And that silence, that deliberate, convenient silence, is exactly why you need to hear this. The Supreme Court of the United States just delivered a ruling that limits the power of federal judges to issue nationwide injunctions, fundamentally shifting how presidential policy gets challenged in court. And almost in the same breath, a federal appeals court dropped an 87-page ruling that doesn't tweak gun law at the margins. It blows the entire legal architecture that anti-gun states have built over decades straight into rubble. Two seismic legal events, one moment. And the people most affected, the law-abiding gun owners, the travelers, the citizens who've been treated like second-class Americans for crossing a state line with a firearm, most of them still don't know what just changed. That's what we're fixing right now. If this kind of reporting matters to you, if you believe Americans deserve to actually understand what's happening to their constitutional rights in real time, hit subscribe right now and turn on notifications. Because the pace of these legal developments is only accelerating, and you cannot afford to be the last one to know. Let's start with the Supreme Court, because the injunction ruling is the context that makes everything else land harder. For years, individual federal judges, sometimes in deeply partisan jurisdictions, have had the power to issue what are called nationwide injunctions. One judge, one decision, and suddenly a presidential policy is frozen across all 330 million Americans, regardless of what any other court thinks, regardless of the democratic process, regardless of the merits. That system has been weaponized repeatedly by both political parties when it suited them, but the mechanism itself has always been constitutionally suspect. And now the Supreme Court has stepped in and said, enough. A single federal judge does not have the unilateral authority to halt the executive branch's agenda on a national scale. That's a massive structural shift in how American governance works. And it sets the table for everything else we're about to discuss, because it signals that the highest court in the land is in a mood to reckon seriously with overreach, including the kind that's been strangling the Second Amendment for generations. Now enter the appeals court ruling. And I need you to understand why this one is different before we get into the details, because I know you've heard the victories before. You've heard about Heller, you've heard about McDonald, you've heard about Bruen, and each time the celebration faded because anti-gun states simply found new workarounds, new legal fictions, new bureaucratic tricks to make sure that even after the Supreme Court spoke, your rights on the ground stayed restricted. This ruling is architected specifically to close those escape routes. A three-judge federal panel didn't just rule against one specific provision of one specific state law. They took an entire residency-based carry permit system, looked it dead in the eye, and declared the whole framework unconstitutional. Not one clause, not one application. The framework itself, gone. And the way they got there, the legal reasoning they constructed, is what makes this different from anything that's come before. Judge Catherine Polk Fail authored this opinion, and what she built isn't just a court ruling. It's a comprehensive historical case for the right to carry arms in public that traces an unbroken line of legal protection across nearly 7 centuries of Anglo-American law. 7 centuries. We're starting in 1328, with the Statute of Northampton in medieval England, running through colonial charters, through the founding debates, through Reconstruction, and arriving at the present day with a chain of legal precedent that is, by any serious constitutional analysis, unbreakable. Anti-gun legal scholars have spent the past several days trying to find the weak point in this opinion. They haven't found it. Because the judge didn't build her case on theory or ideology, she built it on history. And history, when it's accurately documented and properly applied, doesn't care about your politics. Here's the specific legal technique that makes this ruling so devastatingly effective, and it's something that almost nobody in the mainstream press has bothered to explain properly. The judge used what's called negative historical evidence, and this completely flips the script on how Second Amendment cases have been fought since the Bruen decision. Since Bruen, the constitutional rule has been clear. If the government wants to restrict your right to bear arms, it has to prove that its restriction is consistent with America's historical tradition of firearms regulation. So what have anti-gun states been doing? They've been hiring historians to dig through archives looking for obscure 200-year-old statutes, some local ordinance from 1803, some county regulation from 1817, and waving them around as proof that the founders were comfortable with gun control. It's a cynical strategy, and it's worked in enough lower courts to keep millions of Americans disarmed. Judge Fail dismantled it by looking at what historical governments chose not to do. She examined periods of colonial warfare, frontier expansion, widespread civil unrest, documented public safety emergencies, the moments in American history when restricting gun rights would have been easiest to justify, when the political pressure to do so was greatest. And what she found, documented across 23 separate historical examples spanning from 1690 through 1868, is that governments were repeatedly presented with opportunities to ban or restrict public carry of firearms by travelers and non-residents, and they said no 23 times. Explicitly, deliberately, and in every single instance where historical governments did regulate the carrying of arms in public, they did so through objective shall-issue type systems, meaning you meet the legal criteria, you get the permit. No exceptions, no discretion. Never once did a historical government say that some appointed bureaucrat gets to decide, based on their personal judgment or subjective feelings, whether you deserve to exercise a constitutional right. That finding alone is catastrophic for states like New York, California, New Jersey, and Massachusetts. Their entire permitting apparatus has been built on the assumption that discretionary may-issue systems have deep historical roots in American governance. This court just proved with documented evidence that they don't. They never did. The whole thing was a legal fiction invented to keep guns out of the hands of people the political establishment didn't trust, and the historical record makes that nakedly clear. Now let's talk about the sensitive places strategy, because this is where I want you to feel the full weight of how far anti-gun states were willing to go to subvert the Constitution, and how completely this court shut that down. After the Bruen decision came down, gun control advocates went into crisis mode. If they couldn't ban carry outright, they needed another approach. And they found one: sensitive places. The argument went like this: yes, you have a right to carry in public in general, but certain places are so sensitive that the government can restrict firearms there. And then the mission became to define sensitive places as broadly as humanly possible. Airports, public transit, parks, restaurants, theaters, hospitals, sidewalks near schools, sidewalks near government buildings. In some jurisdictions, they were pushing to designate 95% of all publicly accessible space as off-limits to lawful carry, which, if you can do the math, means you have a constitutional right that you can exercise nowhere, which means you don't actually have the right at all. It was a brazen workaround, a slow-motion constitutional nullification dressed up in bureaucratic language. The court saw through it immediately. And the historical analysis they brought to bear on this question is going to rewrite firearms law for decades. The judges went back through the founding era and the entire 19th century looking for historical precedent for sensitive place restrictions. What they found was exactly 4 categories. 4. Where historical governments restricted the carrying of firearms. Legislative assemblies while they were in active session. Courthouses during actual proceedings, polling places on Election Day, and schools. That is the complete historical list. Everything else, churches, markets, public squares, government office buildings, even powder magazines, was historically open to lawful carry. So when a modern state legislature tries to declare a shopping mall or a city park a sensitive place where your Second Amendment rights evaporate, they are not following any historical tradition. They are inventing restrictions that have zero basis in the constitutional record. And under the Bruen framework, if you can't find the historical analog, the restriction is unconstitutional. Full stop. But here's what most people are still missing about this section of the ruling, and it is the part that is going to have the broadest practical impact on gun-free zone laws across this entire country. The court didn't just rule that the list of sensitive places is historically limited to 4 categories. It also ruled that even within those 4 legitimate categories, the government cannot simply post a sign saying no firearms and call it constitutional. The government is required to use what's called the least restrictive means to accomplish its safety objective. That means providing secure storage options at entrances, implementing temporary surrender procedures with guaranteed return, offering specific exemptions for licensed and trained carry permit holders. It means finding ways to address safety concerns without completely stripping law-abiding citizens of their constitutional rights at the door. That requirement, least restrictive means, is going to be the legal torpedo that sinks thousands of gun-free zone laws across the country. Because virtually none of them even attempt to satisfy this standard. They just prohibit firearms and assume that's the end of the constitutional analysis. Under this ruling's framework, that approach is legally dead, and the lawsuits to prove it are already being filed. This is exactly the moment where I need you to do something if this reporting matters to you. Share this video with someone who needs to hear it. Comment below with your state and what you think comes next. And if you haven't subscribed yet, do it now, because the legal landscape is shifting faster than any mainstream outlet is willing to track, and I'm not going anywhere. Now, let's talk about the constitutional architecture of this decision, because this is the element that makes the ruling genuinely unprecedented and, from a legal strategy standpoint, close to bulletproof. Judge Fail didn't hang her opinion on one constitutional hook. She wove together 3 separate and independent constitutional doctrines into a unified legal test that any carry restriction must now survive. And it is a test that virtually no existing carry ban can pass. The first is the text, history, and tradition test established by Bruen. The government must prove its restriction matches America's documented historical firearms tradition. We've covered what that historical record actually shows. The second is strict scrutiny under the Equal Protection Clause, because residency-based permit denial systems don't just violate the Second Amendment. They create unconstitutional classifications of American citizens based solely on where they live. If you're a resident of this state, you can apply for a carry permit. If you're a resident of that state, you cannot. The court ruled that this kind of geographic discrimination triggers the highest level of constitutional scrutiny, a standard that gun control laws almost never survive. The third is the anti-commandeering doctrine, which prevents states from using local regulations to effectively nullify federal constitutional rights within their borders. Each of these doctrines, standing alone, is already extraordinarily difficult for gun control laws to survive. But woven together into a single unified framework, they create a legal gauntlet that is essentially impossible to run, and the equal protection angle deserves special attention because of what it does strategically. When you add an equal protection claim to a Second Amendment case, you change the entire playing field. You bring in a body of law that even ideologically anti-gun judges feel bound to respect. Because the principle is simple, universally understood, and deeply embedded in American jurisprudence, if a right exists, it exists for all Americans equally. You do not lose your First Amendment right to speak when you drive from New Jersey to New York. Your Fourth Amendment protection against unreasonable search and seizure doesn't evaporate because you're a tourist. So why, on what legal or moral basis, has the Second Amendment been treated as a conditional right that disappears when you cross a state border? The judge called these constitutional dead zones, geographic areas where fundamental rights simply stop existing. And she demolished the legal basis for their existence using constitutional provisions that most Americans have never even heard of, including the Privileges and Immunities Clause of Article 4, Section 2, which was placed in the Constitution by the founders specifically to prevent states from creating second-class citizenship for out-of-state Americans. That clause has been gathering dust for over a century, while states built discriminatory carry systems in plain defiance of it. This court just blew the dust off. Now, let's talk about what's already happening in the real world, because this isn't theoretical anymore. The legal domino effect that this ruling has set in motion is moving faster than anything we've seen in Second Amendment litigation history. Within 72 hours of this opinion being published, Second Amendment advocacy organizations had filed 17 new federal lawsuits across 6 different states. 17 in 3 days. Attorneys in California, Hawaii, New Jersey, Maryland, Connecticut, and Massachusetts have incorporated Judge Fail's arguments wholesale into their own filings, not as inspiration, but as direct precedent. California alone is now staring down 5 separate new challenges to its concealed carry permitting framework, including one that specifically targets the state's good moral character requirement, which this court labeled an unconstitutionally vague standard specifically designed to give officials the discretionary power to discriminate against applicants they don't like. That language, unconstitutionally vague, invitation to discrimination, is language that federal courts across the country are now going to be forced to reckon with every time California tries to defend that requirement. Hawaii's situation may be even more significant. The state's entire May issue framework is now under direct legal assault, and attorneys there are reportedly signaling that state officials may not even bother mounting a full defense, because the ruling makes their legal position so untenable that the cost of fighting it may exceed the cost of capitulating. That's how decisive this opinion is. When your own lawyers are telling you the battle is already lost before the hearing begins, you've got a problem that no amount of political positioning can fix. And what's spreading beyond just the jurisdictions directly under challenge is something legal scholars call persuasive authority. This court's historical analysis is so thorough, so meticulously documented, so comprehensively argued, that federal judges in other circuits, judges who aren't technically bound by this specific ruling, are already citing it in preliminary orders. They're signaling that they find the constitutional reasoning compelling enough to follow voluntarily. That's how legal precedent actually spreads in the real world. Not just through binding authority, but through the gravitational pull of a truly well-constructed argument. And this one has it. There's also a psychological shift happening on the ground that doesn't get reported, but that any honest law enforcement observer would tell you is real. Prosecutors and police departments in restrictive states are starting to do quiet cost-benefit analyses on aggressive carry restriction enforcement, and the math isn't working in their favor anymore. Every case they pursue now carries the risk of triggering a federal civil rights lawsuit under a legal framework that strongly favors the defendant. We're already seeing prosecutors in some jurisdictions quietly declining to pursue charges in cases that would have been automatic prosecutions 18 months ago. The enforcement apparatus is beginning to crack, not because the laws have formally changed yet, but because the people running that apparatus can read legal writing on the wall. They know what's coming. And they're starting to adjust their behavior ahead of the formal legal reckoning, which tells you everything you need to know about where this ends. What this court has done, what Judge Fail and the 2 judges who joined her opinion have accomplished, is validate something that millions of law-abiding gun owners have been saying for years, sometimes at significant personal and professional cost. Most gun control laws in the most restrictive states are not built on constitutional law, historical precedent, or genuine public safety evidence. They are built on politics. They are built on fear. They are built on the fundamental distrust that certain political establishments have always had for the citizens they govern. The judges didn't just reject the government's arguments in this case. They went through the government's own historical sources, the government's own crime data, the government's own policy justifications, and demonstrated, point by documented point, that the restrictions were never constitutionally justified in the first place. Not when they were enacted, not when they were enforced, and not now. The legal fiction has been exposed, and you cannot unexpose it. For the ordinary American living in a state like California, New Jersey, Hawaii, or Maryland, a person who has lived their entire life under a system that treated their Second Amendment rights as a privilege to be granted by officials rather than a right guaranteed by the Constitution, this ruling is something different. It is the first time that a federal court has assembled a legal framework comprehensive enough to challenge not just one aspect of that system, but the entire foundation it rests on. If you've been denied a carry permit because a government official decided your reason for wanting one wasn't good enough, this decision gives you legal standing to challenge that denial in a new and powerful way. If you've been turned away from carrying in your state because you happen to live in the wrong zip code, the equal protection analysis in this opinion is your constitutional ammunition. If you travel for work, for family, for business across state lines and have spent years navigating a patchwork of contradictory laws that turned you into a potential criminal for exercising a constitutional right, this ruling begins the process of tearing that patchwork apart. And even if you live in a constitutional carry state, even if your state already treats your rights the way they were always supposed to be treated, this ruling matters to you because it builds constitutional guardrails into federal law that will make it dramatically harder for future legislatures, regardless of which way political winds blow, to roll back your rights. The historical analysis in this opinion doesn't just win a case. It locks in protections at a constitutional level that go beyond any single election, any single administration, any single legislative session. The founders chose not to restrict these rights even during wartime. This court just made sure that legal history cannot be ignored going forward. Here is the question that the political establishment doesn't want you sitting with. If the founders, during periods of actual warfare and genuine civil unrest, looked at the option to restrict carry rights and said no, if they had the justification, the political pressure, and the public safety argument and still refused to build a discretionary system, then what exactly has been the basis for a century of restrictive permitting laws? What legal or moral legitimacy did those systems ever actually have? The answer this court is giving us, backed by 7 centuries of documented history, is none. They had none. And the people who built those systems, who enforced them, who prosecuted law-abiding citizens under them, they built their entire apparatus on a foundation that was always constitutionally hollow. The question is no longer whether the remaining restrictive states will fall. That question has been answered. The question is when, and whether the officials running those states will accept the constitutional reality gracefully, or whether they'll make their citizens fight for every inch of ground that was always rightfully theirs. Based on the legal momentum already underway, based on the 17 lawsuits filed in 72 hours, based on the prosecutors already quietly retreating from aggressive enforcement, based on the federal judges in other circuits already citing this opinion voluntarily, the timeline is shorter than anyone expected. The walls are cracking. The legal domino effect is accelerating. And the people who spent decades telling you that these restrictions were constitutional, that discretionary permitting was historically grounded, that sensitive place designations were a legitimate exercise of government authority, they are running out of places to hide from the historical record. This is one of the most significant Second Amendment developments in modern American history, and it is moving in real time. Every week, there will be new filings, new rulings, new states forced to reckon with this legal framework. The momentum is real, the legal architecture is solid, and the consequences for millions of Americans are enormous. If you want to stay on top of every major development as it breaks, if you want reporting that doesn't soften the reality, doesn't wait for mainstream permission to call something significant, and doesn't pretend that your constitutional rights are a partisan issue rather than a fundamental American one, then subscribe right now, hit the notification bell, and drop a comment below telling me which state you think cracks first. Is it California, Hawaii, New Jersey? Tell me what you're seeing on the ground. Tell me what this means for you personally, because this story is far from over. It is just beginning, and I will be here every step of the way, making sure you know exactly what's happening to your rights in real time. That's the job, that's the commitment, and we're not done yet.